Hi there, this is Billy Tarasio with the Modern Divorce Podcast, back again for a really fun episode today. I am talking to a Washington State attorney, Michelle Delino, and we are going to talk about the rights of cohabitating couples, which is totally different in Washington than it is in Arizona, and it's absolutely fascinating. Michelle, welcome to the show. How are you doing?
Great. Thanks for having me. This is awesome to be here and excited to talk about it. It's so different than Arizona.
It really is. Now, before we get started, can you tell everyone about what it is that you do and your firm and your practice up in Seattle?
Yeah, absolutely. I'm managing attorney of a family law firm in Seattle. We have 6 family law attorneys and we handle all kinds of stuff. So we handle basically all your what people would call regular divorces, uncontested divorces, but we handle a lot of messy cases. So if you have a messy family law case, something high conflict, when stuff gets dirty, people come to us. So that's what we do.
Fantastic. And how long have you been doing that?
Our firm started in 2013. So we are now, I think, going into we're in our 8th year, in the middle of our 8th year. So that's really exciting. And we've grown exponentially since then. I've been practicing family law since 2009. So it's kind of what I know and what we like to do.
That's fantastic. It's great to have you on. And I want to talk about what are the rights of cohabitating couples.
Yes, great question. So totally different than probably what you're used to.
Well, right. So I had somebody call the other day who said, we've been together 23 years. We've both been paying the mortgage. His name's on the house. We have 3 children. What are my rights?
Mm-hmm.
And so if I were asking you that and the situation was in Washington, what would you say?
I would say 23 years. You have what in Washington, when you get in marriages, when you get around 25 years, it's a long-term relationship marriage. So I would say, wow, 23 years, been together a long time. I'd want to know when they started living together. That would be a big thing because a lot of people say, oh, we've been together this long, but turns out we only lived together for 2 years. So assuming they've been together and lived together the whole 23 years and they've got kids and this is the whole thing, and they are what we would call a couple that would likely be eligible to have their relationship dissolved as a committed intimate relationship. And I would tell that person, hey, you have property rights. You basically get everything that a married couple would get aside from 2 things. And we'll talk about that in a minute. But you have a right to a community property interest in anything that was acquired during the marriage. Sorry, the relationship, not the marriage. So let's say in those last 23 years, one party has the house name on title, that party has a bunch of retirement accounts, brokerage accounts, things that were earned during the long relationship. The other party, the financially disadvantaged party, has an interest in that, even though they never married. So improving that can be difficult in some cases, but in a 23-year relationship where they've got kids, it's probably not going to be that difficult, and they're going to be entitled to just an equitable share of the community property, which is probably going to be a lot.
Okay, so it is crazy to me that you would be speaking this way because we're a community property state as well.
Right.
And the community is the marriage.
Yeah.
But there is no community property if there's no marriage.
Yeah.
And so unfortunately, I have to tell those clients, like, you have no rights. Your rights are subject to contract law, subject to real estate law. If you had some sort of breach of contract claim, maybe we could do something there, but there is no community. So how do you have community property rights?
Right. And totally different for us because we call it, it's community-like, but we're quasi-community. So that's what we term it. But basically we determine when did that begin and when does it end? I mean, obviously you've got a date of separation like you would have in a marriage, but in Washington, it's interesting because these relationships used to be called meretricious relationships. Then they evolved to a friendlier term, committed intimate relationships. But what really happens is there was a 1995 case where, and there were other cases before that, but in 1995, a Washington court, the case is called Connell versus Francisco, in case anybody cares, but they essentially evaluated a number of factors and found a committed intimate relationship and found that property could be divided under these factors. So the court will look at things like, and when you're working on a settlement, I would ask people things like, to determine what the deal is, How long did you continuously live together? What was the purpose? Because if you're just roommates, like that doesn't count. It has to be an actual like relationship, intimate relationship. Was the relationship stable, or were you breaking up all the time? What was the purpose? Was it to raise a family? Was it for mutual love and support? So we want to know what the purpose is. And then we would ask things like, did either of you put one another on insurance benefits? Did you pool resources? That's a big one. So both people put money into a joint account, but even if you didn't have a joint account, you could still have a committed intimate relationship, which blows people's minds even more. But, we asked things to kind of determine what was the relationship like. And if it was a marriage-like relationship, the courts in Washington specifically look for stable marriage-like relationships. And then the courts have the right to divide property. So it's mind-blowing to people in other community property states.
I mean, it really is, because, you have a couple who did not get married. They did not opt
On purpose.
that construct.
Yeah.
Yes, they intentionally and they knowingly are not married.
Right.
But I guess it is a little bit like the concept of a common law marriage. And usually when people call me and they say, we've been living together for 23 years, we have kids, don't I have a common law marriage? And so maybe we should talk about that for a minute. I'm assuming that Washington does not have common law marriage.
No, we don't. And people call that and ask all the time. And then we can say, no, we don't have common law marriage, because I think very few states actually really have that anymore. I'm not sure how many, but we'll say, no, we don't have that, but we do have committed intimate relationships. So let's break it down and talk about what's going on with your relationship and what that might have been like. And then some people don't, usually get two different people looking at that. You get the people that want to say, hey, I have a common law marriage, or now I have a committed intimate relationship. Those are the people that want to divide the property. Then there's the other party that's like, I didn't marry him or her on purpose. There was a reason we didn't do that, and I don't want to have to give them any money. So
right.
Yeah, but everybody says that. Everyone says, don't I have a common law marriage? And no, the answer is no, but you might have a committed intimate relationship. So it's really interesting. Also, we look at it, people looking backwards and thinking, hey, how do we divide this property? And then we look at it with people looking forwards and trying to plan for living with someone and how we can help them avoid that happening, or at least planning for what it's going to look like if it does happen.
Yes. So it seems to me that people are probably entering committed intimate partner relationships unknowingly.
They have no idea. Yeah.
All the time.
Yeah.
Because for a common law marriage, you had to hold out as marriage. You had to act married, and that does happen. I mean, I do know couples, especially those receiving spousal maintenance, who go and don't get married but hold out as if they're married because they'd like to be married, but they want to still get their spousal maintenance. Exactly. And in some ways, that seems a little bit more like legitimately fair. To say, we're going to treat you like you're married because you acted like you were married and you claimed to be married. But in this case, it's just such a gotcha. And I imagine there's massive litigation about what happened during the marriage or during the relationship.
Yes, totally fact specific. I've tried committed intimate relationship cases, and it is completely a testimony heavy case where people are coming in and saying, oh, well, some people will even say, I thought they were married. They were together so long, I didn't really know. Or some people will say, I proposed. A big thing that comes up too is like, did other party propose and the other party said no? If that happened, why did they say no? Was it because they were thinking because it wasn't a stable relationship, or was it because they really just made this decision together? So there's a lot of testimony about what happened during the relationship. And really, as we get ready to settle these cases, because they don't all go to trial, there's a lot of discussion about, what can be proved. Well, were you on bank accounts together? If not, why not? Did one party give money to the other party and that party paid all the household bills? Like, what was really going on is really something we have to take a deep dive into to figure out who's got the stronger case. So it's interesting that also too, I had a case maybe like 5 years ago where the parties were together barely over 2 years, and yet one party moved from Hawaii, I think, to Seattle to live with him. They had a child right away. And then, and the other party bought a house during that time. The end of the case, even though it was barely over a 2-year relationship, the person who moved there got the house the other party bought. And it was a committed intimate relationship. So stuff like that can happen. I mean, it was a hot second relationship, but a lot of stuff happened in those 2 years. So there you go.
Oh my gosh. That is just frightening to me
Yeah.
as a divorced person who would not want to end up like
Right.
accidentally opting into something. It really does make the case for the prenup, postnup,
Cohab.
agreement.
Yeah. That's
So
the
we
thing.
don't need,
Cohab.
yeah, so we don't have cohabitation agreements in Arizona nearly as often, although if you have a couple that is cohabitating and they intend to provide something for one another. Let's
Mhm.
say somebody doesn't want to get married and the other person says, I feel uncertain about my future. I'm not going to continue living with you unless I know what happens if we break up.
Hmm.
That would be a completely, perfectly legitimate adult conversation that could result in a cohabitation agreement.
Ah, interesting. And that's different than how I would look at a cohabitation agreement. Yours is like, we want to provide, even though we don't have to give the other party security. Sometimes we'll have that, but more often than not, it's we want to define what our property rights are if this ends, because if we don't, the court can. And so that's a whole other thing. And I think it's notable too, that in Washington, the court has said that if one party dies, you don't inherit the same way in a committed intimate relationship the way a spouse would. So you don't get those rights. A lot of people want to know, like, oh, what are the differences? Well, you don't get the rights of, you don't get Social Security benefits because that's a federal thing. You don't inherit under Washington law. So that's a thing. But a lot of the time people will draft these cohabitation agreements and they'll either want to include property rights after death, or they'll want to include additional things, or they'll want to just make it very clear that that's not happening. So it's kind of probably different than the people that would come to you and say, oh, I want to provide for so-and-so because I want to give them security to live with me and not marry me. And in our situation, we're mostly saying we want to make sure everybody's stuff is not becoming quasi-community.
Absolutely.
Yeah.
And the reason is that the risk is totally shifted. So
yes.
in
Oh,
Arizona,
totally.
the risk is completely on the non-owning, non-earning, or lesser owning,
Yeah.
lesser earning, owing, all of those things, spouse or person,
Totally.
versus in Washington, where the risk is really on the person who has more income and more resources.
Yeah, and we're seeing that more and more with younger people because they have no idea. How would they know? Why would they know? But then we have a lot of people, who even in their 20s might go to work somewhere like Amazon or Microsoft, and they're cohabitating with someone. And in the middle of that cohabitation, they might get a massive stock grant. And what they don't realize is, oh, hey, I got all these restricted stock units that are going to vest, stay living with my boyfriend or girlfriend for 5 years. And that person maybe, doesn't work at Amazon or Microsoft. And then the relationship ends. And I realized those hundreds of thousands of dollars in stocks that are vesting, they were granted during the relationship. So they're quasi community potentially. And that person, like you said, has all the risk. So it's a lot of times when someone hears, oh, geez, I'm living with someone, I might have risk. Then they say, what's going on with cohabitation agreement? Can I do that? And then you have to have the delicate conversation with the other party, explaining why you're doing that or how it works. But I try to tell people it's actually a time saver and a stress saver for both parties, because to litigate one of these cases is expensive. And another major difference in Washington is that in Washington, we have the ability to seek attorney's fees under a need and ability to pay standard. So if somebody really needs fees and the other party really has the ability to pay in a marriage, you can do that. In a committed intimate relationship, you can't. So you're each equally responsible for your own attorney fees. So if that financially disadvantaged person wants to say, hey, I have a claim to all that, you have to have the money to fund your own litigation. So I tell people, by doing a cohab agreement, you can be really clear about what's going to happen. You don't have to wonder what's going to happen. Maybe you never need the agreement, but at least you know.
Wow.
So, yeah.
Wow. Absolutely crazy. Okay, now the other question I want to ask is, so in Arizona, our presumptions are different. But the presumption is, if you're married, whatever you create together, any work you do is on behalf of the community and is community property. Now, many, many times people will take title to a house in one name.
Right.
And in Arizona, the presumption is if it was acquired during the marriage, it's community. However, if somebody signs a disclaimer deed, that's also evidence of an intent to gift away your interest. Right. So the gifting analysis becomes very important. And let's see, I don't know that I remember legally what's a gift from law school. I think I do. Do you remember what are the elements of a gift?
Oh gosh, no. That's a good question too.
All right, we'll just talk out loud. I think it's
Yeah,
you had the property and it was all yours.
right.
You give it to someone and then you no longer have any control or claim over it. You give it to them.
Yeah, yep.
So there can't be any strings.
Yeah, exactly. There can't be any conditions. It has to be
Right.
an unconditional gift, right?
Can't be
Right.
like, you get to stay in this house until you're done and then
But I can pull it back.
Yeah, that's not a gift. And then the other thing is you have to intend to give
Yeah.
it.
Oh, the intent is everything. That's remember. Yeah. It's what you intended. Yes, exactly. And that's, I would think that would be interesting, especially where you don't have committed intimate relationships. If I gave you something, that's basically dispositive of what it is. There's no question about it. And we have a lot more to weed through because people might not hold something in title, but that doesn't mean anything.
Well, in Arizona, it could mean something.
It could,
Our job
yeah.
as lawyers to say, well, why did this happen? Like what made you sign this disclaimer deed and give up your interest? You know, did you know what you were signing? Did you know what the result would be at that point? And Arizona is very like, if you as an adult, made a decision, you got to live with the consequences.
You're stuck with it.
Yeah. So in an intimate partnership, I would think there's a ton of evidence of intent.
Ton. That's really the main thing, because everybody wants to know what was the intent of the parties and what was the purpose of the relationship. And those two things really go hand in hand. Like, what did you intend to do? And a lot of the time too, maybe one party will be on title for the house. And then you have to look at, well, why wasn't the other person on title? Were they not on title? Just because, number one, they're not married, so there's not a requirement to sign a quitclaim deed, or were they not on title because credit was an issue? That comes up a lot. It comes up in marriages too sometimes, when people will sign a quitclaim deed to disclaim their interest, but they only did it because it was for financing. So then you get into talking about that. So yeah, intent is huge. I recently had a case, I think it was actually ended last year, and the parties lived together continuously for 10 years, and then they got married, but when they got divorced, they were only married for 9 months. So one party is like, oh, this is a 9 month short-term marriage, this is nothing. The other party is like, yeah, this is 11 years. And so that creates like a huge difference. So then there was a lot, and the case went to trial. So there was a lot of deep diving into those 10 years prior about what were they intending to do, what was their plan, how were they planning, and these people were like kind of planning together for retirement. So even though they didn't marry until the end, and it really wasn't decided that they would marry until the end, everybody wanted to talk about what they intended to do, including the parties. So yeah.
Wow. Okay, can we talk for a minute about spousal maintenance?
Yeah.
Because spousal maintenance is another area that's just so usually different and interesting. So how does spousal maintenance work in Washington?
Great question. So first of all, you don't get it in committed intimate relationships, off the table there. Yeah. Two things you don't get. You don't get spousal maintenance, and you don't get attorney fees. So if somebody says, oh, like that 20, if you were talking about that couple that was together 23 years, I would say, hey, you're going to have an interest in the property rights, whatever is in the community like pot, but you're not going to get spousal maintenance. And I tell them that right away. And then they always say, well, what about alimony? And I'm like, well, spousal maintenance is the Washington term for alimony. So you're not getting either. It's the same thing. But in Washington, we don't have a statutory formula. It's very discretionary, and the court looks at maintenance as a tool it can use to put the parties in essentially what they think are a just and equitable position. So if you're in a short-term marriage where you're married maybe 5 or 6 years or less, the court wants to look backwards and say, hey, we want people back where they started. Nobody should really be profiting off this marriage. Yeah, you're going to divide the community, but maintenance is usually on a 4-to-1 formula. So 4 years of marriage, 1 year of maintenance. That's typically how it works. And only if there's really a big discrepancy between how the parties are exiting the marriage as far as income. Otherwise, maintenance is going to happen. Midterm marriages in Washington is where most of the maintenance is, probably like Arizona. People that are, 5, 6, 7 years, all the way up to, 20 plus years. That's a midterm marriage. And the idea is to rehabilitate people and give people support to get back on their feet and then get off of maintenance. So And it can be flexible, either somewhere from 3 years to 4 years to 1 year of maintenance to 1 year of marriage. So, I mean, you could have a 20-year marriage, and if you were on like a 3-to-1 ratio, you're probably looking at like 7 years of maintenance, and then maybe it starts out equalizing the parties with income, and then it tears down because that other person's supposed to be getting rehabilitated. And then in a long-term marriage, up around 25 years, the parties are supposed to be equalized indefinitely for life. So that means looking at their Social Security benefits and figuring out where people are going to sit post-retirement. What about Arizona? I don't actually know. Is it similar?
No.
No, of course not.
As you might guess, Arizona awards are, they're structured differently, and generally speaking, philosophically, Arizona is not as generous with their spousal maintenance awards. So it's so interesting to watch the culture of a state, which is not that far apart, feel so differently about these concepts totally. Of support and responsibility and all of these things. So, in Arizona, it's not easy to get. You have to qualify first for spousal maintenance, and there's 5 factors that you can qualify under. Almost anybody can probably get beyond the qualification rung. Not everyone, actually. You have to qualify. You qualify either by being unable to meet your own reasonable needs, or by making significant contributions to the other party to the detriment of your own. Those are essentially the ways.
Like staying home to take care of kids, that kind of a thing. Would that qualify you?
Yeah, you got to even do better than that. You have to really, like, let's say because first of all, that person would have to be working now. Otherwise they get in under, I can't meet my own reasonable needs.
I can't meet my needs, sure.
But let's say that this person is a nurse now, and they stayed home for 20 years, but now they're a nurse, and now they're making $60,000 or $70,000. They may have a hard time qualifying, because they can meet their own reasonable needs. So now we have to look at, did you make a significant financial contribution to your spouse's income? And that's not automatic. Like, we have to actually, okay, well, I guess it depends on what that spouse is doing. Let's say he's a teacher and he was always a teacher, and like they're making about the same. Like, it doesn't matter that you stayed home for 20 years, you're not going to qualify.
Yeah.
So once you qualify, then there's 13 factors, that are all the things like lifestyle and ability to pay and all of those things. And did you waste any money? And to figure out the amount and duration. But so it's really a 2-part analysis, but they don't have this concept of short-term, medium, long-term. And then I used to practice in Oregon, and Oregon had these 3 separate pieces of spousal maintenance. You could have rehabilitative, compensatory, or permanent.
Compensatory. Whoa.
Compensatory, which and those 3 concepts are kind of what spousal maintenance is really all about. Rehabilitative, like we get you on your feet. Compensatory, we pay you for what you did, your contributions. Or permanent, we don't, you've been married a long time, and
you're getting it.
You're getting it forever. So it's a very different construct. All 3 states are very different.
Totally. I think you're right too. Just the social attitudes of the different states kind of shape a lot of that. Washington is extremely liberal with maintenance, extremely liberal with property, obviously extending to unmarried couples. So, and it's deeply rooted. In Arizona, I'm surprised about the maintenance being so hard to get. I didn't realize that. It's not a given. Like in Washington, you could basically make an argument that you have a need, and you could get temporary maintenance awarded to you in 2 weeks. So, and then you could get that maintenance award, and then you could ride it out for a year until your case goes to trial. So, that happens a lot in different cases. It's not that hard to get, and it's completely discretionary. So it sounds like in Arizona, the barriers to entry are a lot different.
A lot different. There is no doubt in my mind that in Arizona, the higher earning spouse will almost always walk away and continue their life in a much better position than the lower earning spouse, the lower educated spouse. And so it's a different version of buyer beware. Like, if you are in a traditional marriage and you are depending on this person, and you're not kind of investing in yourself and your own resources and your own ability to take care of yourself, like, you are at a huge risk in Arizona.
Wow, that's really, and it's exactly, I mean, I would still want to tell anybody, hey, you're in a risky position because it's going to be hard for you to rebuild your life. But I actually tell clients the less moneyed spouse is ironically the spouse with, I'd much rather go to mediation with that spouse. We have all the power. We know the other party's going to pay. It's just a question of how much. I always tell them that you went through your whole marriage feeling like you didn't have any power and you've got no options. You do now.
Wow.
So, and the other party that has the money and has the career is usually going, ooh, how do I mitigate my damages?
Right.
So it's a little role reversal
Uh-huh.
because that person who didn't have money and might not have an education, they have all the power now because they can say, okay, this is what I'm going to need. This is what it's going to take for me to get on my feet. We're totally like this, and you need to bring us like this. So it's completely the opposite, because you're saying, hey, that person who's, making the higher income is going to leave the marriage in a better spot. And most of the time in Washington, the person who makes less and has less is going to leave the marriage in the better spot.
Just crazy.
Yeah, because in Washington, the court would say the more moneyed spouse they're gonna be able to recover financially from the divorce. So get to it, make your money and recover. You already can. The other person, nope, they're gonna say you're gonna take a big disproportionate cut of the community. If you've been married quite a while, you might get 60-40 and you get maintenance. So you're gonna leave taking a bunch of the property and you're gonna get maintenance to get back. Then you still have to figure out how to take care of yourself after that, but you're going to leave the marriage at least immediately in a way better spot.
Wow.
Yeah.
Shit, crazy. And you know what would be interesting would be to wonder, does that impact divorce rates at all? And I
think it does.
You think so?
I do. Well, I know, and okay. Nationwide, I don't know. And I do know that there are people, I have had clients myself and talked to other attorneys who will say, they put off getting divorced because they knew they were going to have to pay. Or maybe they come for a consultation and I'm like, yeah, you're going to be paying this much. This is what's going to look like for you, because I don't want to just tell you what you want to hear. And then they're like, oh, I'll try to make it work. And then they come back a year later. Yeah, it didn't work. So, I think people are hesitant inherently, especially if you have amassed a certain amount of, investments or whatever, realizing that it's basically it's going to get gutted. So you're going to be paying. So a lot of the time, I think I've experienced there's more of an effort to make things work. Not that it matters most of the time, because if you're already thinking about it, it's probably not going to work. I also think too, the inequity in relationships like that contributes to it, maybe just as much, if not more, than, someone feeling like I don't want to write a check every month. But yeah.
Well, we know that is for sure true where women out-earn men.
Yes.
The divorce rates for women who out-earn men, or for marriages where the man is chronically unemployed,
right,
that's almost certainly going to end in divorce, at least statistically. Yep. And so it's a really interesting philosophical question of, does the legal system matter at all, or is it just about relationships? Do relationships really just break down when they break down, and it doesn't really matter what the state does about it? I don't know. That's
a really good point when you put it that way, because I can say, oh, hey, I think they're putting it off because they don't want to pay, but it's going to break down eventually. So it does create that total philosophical question of, do relationships just fail because they fail? Does it matter where you are? It's definitely more advantageous to be certain places depending on what situation you're in. But a lot of the time, sometimes I'll tell people, we have a lot of people that move from California, and they'll be like, oh, they're unmarried. And I'll say, yeah, you should have broke up while you were in California, because there's no rights like this there. But the relationship was going to end. And somebody might say, oh, we were going to break up before we moved here. I wish we had. I don't know, but they still broke up. So it didn't really matter where it was. It just changed their outcome drastically.
Right. Well, and it certainly makes our jobs interesting. We have to work within the construct that the state gives to us. Right. And then we do what we do. But the moral of the story here for anyone listening to this very interesting podcast is prenuptial agreements, postnuptial agreements, and cohabitation agreements are your friend. No matter where you're located, you can either, by virtue of where you're living, you are opted into a system that you didn't design for yourself, that may not reflect your values and that may not be good to you or your partner. Or you can design a construct for yourself that is fair. And I just think, 10 times out of 10, you're better off designing your own construct.
Absolutely. Because if you don't design your own construct and say, these are the terms we want, not whatever our state is going to decide, you're going to fight about it later when you're in an emotional space where you're basically angry or desperate or something. And so you're going to have to try and negotiate that at some point before, and it's either just going to be before the laws of the state are applied for you in a trial setting, or you're going to try to negotiate it in mediation later. So it's much better to do it up front when no one's angry too. And everyone says, hey, let's get this, let's determine our own construct for what our relationship should look like if it fails, not leaving it up to someone else and not spending tens of thousands of dollars fighting out about it whenever that may happen, if it happens.
That's totally true. And it's also like the concept of when you're negotiating in advance, you don't know if you're going to be the one leaving or staying. And so it's almost like when your mom would say, take the candy bar and one person cuts it in half and the other person picks, because you don't know which side of the equation you're going to end up on. So you really want to be fair. You really want to be looking out for both sides. But instead, the Washington construct will push for the lower income partner to be, emboldened and emblazoned and walk away with as much as he or she can. Yes. And the Arizona construct really sets up the higher earning spouse to simply wait out and outspend and outmaneuver the lower earning spouse.
Wow.
It's just the way it is.
Wow, that's crazy. Let me ask you really quickly about attorney fees. So if the lower earning spouse doesn't have access to the community money, they don't have a joint account, or they're not on it, can they seek attorney fees like the way we could in Washington?
Yes, although temporary attorney's fees are not awarded all that often. You're really almost better off. I mean, attorney's fees are more often awarded at the end, which is not helpful if you don't have any money to fund your divorce. But the other thing that you can do is when you've got a liquid fund or any sort of fund, you can ask to split it in anticipation, which is usually the stronger argument.
That's good. Wow. And that's totally different. Again, that's totally different than Washington, where we might have, it's a given that you're going to be able to go to get a temporary order for attorney fees. Then we could go back and say, hey, we need more. This is the stuff we need to do. And they'll have to, the higher earning spouse will have to pay it. But that makes a lot of sense. If there's something liquid, you could say, hey, let's tap this. And
it's community property. It should be divided. Why should one spouse control it all now?
Right.
So Arizona can get behind that.
Harder to get fees. It's harder to get fees than, like you said, so somebody would actually have to fund their case kind of all the way till the end in some cases where there's not a liquid asset. Wow.
Yeah.
That's crazy.
Yeah, it really is. I think the Arizona construct does encourage settlement, especially we haven't talked about the kiddo stuff, but in Arizona, there's a presumption for equal parenting. Yeah. And there's a presumption for joint legal decision making. And it's not technically a presumption, but it's a presumption. And that also tends to really encourage settlement, unless we're dealing with something like a relocation where you can't settle that. There is no 50-50 on a relocation. Right. But if we're dealing with two parents that are local, who are good parents and there's no abuse, there's really no reason to litigate that. Now, is that the same in Washington?
Not exactly. We have a presumption for joint decision-making. We have a presumption, we have physical and legal custody. So we have a presumption that there's going to be joint legal custody. Physical custody, it's not, there's no, in some counties, like in Seattle, we're moving more towards seeing more 50-50 plans unless there's a reason not to, but that's relatively new and that's not a given. And really in general, up until very recently, it was still like one parent has every other weekend and maybe a midweek visit. And even now in some areas, it's still that way. So there's not really a presumption for equal parenting. It's essentially looking at what is the situation. And, I think more than ever, if we could move towards a 50-50, there would be less presumption. There'd be a less reason to litigate as much as there is, because there are some people that will still die on the sword for every other weekend, even though that's kind of something most places are saying, we're not doing that anymore.
Right. Yeah. So interesting. Thank you so much for your time today. It's been absolutely fascinating. And we will make sure to link in the comments to your website so that if people are in Seattle and they need a family law attorney, they can come see you.
Great. This was fun. Thanks a lot. It was very educational.
Thank you.
All
Bye.
right. Take care. Bye.